Imagine a law that strips you of every right you have, and you can't even take it to court. Sounds like fiction, but in the early 1970s, this was almost India's reality. This is the story of a prime minister and a humble monk from Kerala, a 68-day legal war that gave India the doctrine protecting its democracy to this day. Welcome to the Instinct Story, where the extraordinary stories that shaped modern times come alive. A brief disclaimer. This is not a legal analysis of the Keshavananda Bharati case. It is the story of a landmark constitutional judgment widely regarded as having preserved the basic structure of the Constitution of India, a story of enduring importance for anyone interested in democracy, constitutional law, and the rule of law. Our story starts not in Parliament, but in Kasaragod, Kerala. Meet Sri Kesavanand Bharati, the 29-year-old head monk of the Ednir Mutt. In the late 1960s, Kerala's land reform laws seized a huge chunk of his monastery's land. That land funded the Mutt's schools and charities. Without it, everything was at risk. Frustrated, he did something nobody expected. He decided to fight back in court. Meanwhile, in Delhi, Prime Minister Indira Gandhi was pushing sweeping reforms. But every time her government passed a law, the Supreme Court struck it down. Furious, she used her majority to pass crushing constitutional amendments. These amendments gave Parliament near total power, even over your fundamental rights. To hear Keshavananda Bharati versus State of Kerala, the Supreme Court of India constituted the largest constitutional bench in its history, a bench of 13 judges. The size of the bench reflected the extraordinary constitutional importance of the issues before the court, which would ultimately reshape the relationship between Parliament and the Constitution. A legendary, brilliant lawyer whose oratory skills could spellbind an entire room without looking at a single note. Nani Palkhivala stood for the citizen. His argument was simple and devastating. The Constitution, he said, is a gift given by the people to themselves. Parliament is merely a creature of that Constitution. He famously argued that the word amend means to improve or tweak, not to destroy. You can repair a house, but you cannot tear down its foundational pillars and still call it the same house. Arguing for the government were H.M. Sirvai and Niren D. Sirvai was already a legal legend, widely regarded as one of India's finest constitutional jurists. Despite being offered judicial office on more than one occasion, including a judgeship of the Supreme Court of India, he chose to remain an advocate, believing his true calling lay at the bar. The government's lawyers counterattacked aggressively. In a democracy, they argued, the people elect Parliament. Therefore, Parliament represents the absolute will of the people. If the elected government wants to rewrite the Constitution to bring economic equality and remove poverty, an unelected group of judges has no right to stand in the way. Parliament's power under Article 368, they insisted, was absolute and without boundaries. On April 24, 1973, after 68 days of intense arguments, the 13 judges delivered their verdict. The judgment was a mammoth 700 pages long. And the outcome? A razor-thin, dramatic 7-6 split decision. The bench was split dead even. One man's vote would decide India's fate. The dissent. Led by Justice A.N. Ray, 6 judges voted entirely in favor of the government. They argued that Parliament's power to amend was absolute and unrestricted, that imposing limits on this power would undermine the sovereignty of Parliament and block national progress. The majority. Led by Chief Justice S.M. Sikri, 6 judges voted for the petitioner. They argued that human freedoms and fundamental rights cannot be completely destroyed in the name of a welfare state. there are inherent, implied limitations to what Parliament can change. The entire fate of India rested on one man, Justice H.R. Khanna. In an act of pure judicial brilliance, Khanna found a middle ground. He agreed that Parliament could amend fundamental rights, but it could not touch the fundamental architecture of the system. His vote created the 7-6 majority. And just like that, the basic structure doctrine was born. Democracy, secularism, separation of powers, judicial review. The Constitution's untouchable core. The immediate fallout of this judgment was pure political drama. Chief Justice Sikri retired the very next day. Furious with the judgment, the Indira Gandhi government broke a long-standing convention of seniority and promoted Justice A.N. Ray, who had voted for the government, to Chief Justice, superseding 3 senior judges, Justice A.N. Grover, Justice J.M. Shelat, and Justice Y.S. Hegde, who had voted with the majority. Those 3 judges resigned in protest. And Kesavanand Bharati? He lost his land. The court upheld the reforms against him. He lost his battle. But the people of India won the war. So why is this the most important judgment in Indian history? First, it stopped authoritarianism. Second, it protects your rights. It ensures that no matter how massive a political majority wins an election, they cannot simply wake up one day and strip citizens of their fundamental right to equality, freedom of speech, or life. And third, it keeps the Constitution alive. It balances Parliament's power to change laws for modern times while anchoring the core values the Founding Fathers fought for. Today, the basic structure doctrine still stands as India's constitutional shield. Kesavanand Bharati passed away in 2020, having never read his own 700-page judgment. His fight over a small piece of land ended up saving the world's largest democracy. If you enjoyed this story, like, subscribe, and let me know. Should judges have the power to stop Parliament?